Good morning. Nice to be here. Thanks.
We're having some, we can't hear you, Ed.
Until you can afford.
Ed, we are having a little difficult time hearing you. You're cutting off.
Yeah, if you get closer to the mic, perhaps, maybe.
Right. Or how to preserve.
Maybe he should call in.
Yeah.
The restriction or Congress. That's called
Ed,
registration
you don't have
also.
your phone on, do you?
Nope.
No, it's just the computer. Because your voice is breaking up.
Yeah, I can see that the motion pictures are.
Maybe you want to call in to this.
No, I don't have any mute.
I think it's Ed. I think it's a connection issue. Can you call in?
Sure.
Yeah, let's try the phone.
I'll put up my slides.
If you just turn your video off and just talk, see if that is better.
Okay. Except I want to show the slides.
You can send them to Garish.
Yeah, so maybe send them to Garish or Raja.
And you can go ahead and send the slide to Girish and we can.
Here they are. Here's the slides. Okay.
Can you see the slides?
Yes.
Okay. I'll have to call in.
Your audio is fine now, so let's try.
Now it's a lot better. So maybe we continue with this.
Okay. Most entrepreneurs who have an idea can't afford the $4,500 cost of registering their idea, but there are with it.
Ed, you are still breaking off, so it might be better for you to call in.
Trademark with the U.S. office.
Ed, you might be better off
And
calling. I think your voice is breaking up again. Your sound.
Okay, I have to escape the slides back to the 12-digit number. Oh, the email doesn't have a phone number.
I can text that to you. Give me a second. Christine, can you go ahead and text Ed the phone number that he can call in?
Sure thing. I'll send it in chat.
Yeah. So Ed,
Do you have my-
look out for that number in chat. So it should be coming here. Did you get a chance to send that, Christine?
I did. I sent it over to him.
Okay, great. Ed, did you get the number?
I did, but they say the meeting ID doesn't exist. Let me try it again.
You sound better now. And one thing that you may want to try is that you're sharing your screen and you are running, instead of running the slideshow, you may just want to go one slide at a time and see if that is better.
Okay, this is Ed. Can you hear me now?
Yes.
Yes, we can.
Hello?
Yes.
Yeah, we can hear you.
Okay.
All right. Maybe you want to take it from the beginning with all the yes.
There we go.
Okay, we're going to talk about patents first.
Once you reveal your idea, you can't patent it anymore. Because the purpose of the patent registration is to share with the world what you've invented. And if it's already been shared, it's not eligible anymore. So you must get a non-disclosure agreement from everyone you disclose your idea to. They also work for copyrights and trademarks, but they're not essential for anything but patents. a patent is an idea for a machine or something tangible. Score Mentor has a confidentiality agreement that we use for business plans. When we reveal them business plan to potential investors. Trademarks are easier. You can preserve your right to file on them by putting the superscript TM at the first mention of each mark or verbiage that you want to trademark. So you see the superscript TM. That's all you have to do to preserve your rights. Copyrights are similar. You have to add the words all rights reserved. Your name and the year first disclosed to the writing you want to later copyright. So when you have preserved your rights, you have a deadline. You have to find an intellectual property lawyer, and by the way, they are a separate set of lawyers. There's about 2,100 of them. They're admitted to the patent office after they take an examination. And the filing fees are about $1,500, and the lawyers, most of them charge around $3,000. So does anybody have any ideas that we haven't talked about that they'd like to ask how to preserve?
Yeah, we'll ask everyone to put their questions into the chat, and we'll get to them in the course of our discussion. So Ed has really kind of just given us a broad understanding, or at least what is out there in terms of trademarks, patents, and copyrights. And we want to have a real dialogue with the rest of the group as to what some of their own experience has been, and if they have specific examples or questions related to the kind of work that they are engaged in. Let me start off, Ed, by just asking, how do I find out if my invention is already out there? What if I come up with an idea and maybe somebody's already thought of it before, and how does one find out?
Well, with trademarks, it's easy. You can have a lawyer admitted to the patent office run a trademark search. It's done by computer, like any search engine, as long as you're admitted to the patent office. And as a result, it's very inexpensive. Patents are harder. You can run a patent search also, but patents are based on the claims made for the uses of the idea. And so what you get back on a patent search is a lot more ambiguous. You have to study the claims made to see if they interfere with your claims. Copyrights, there you can search at the Library of Congress too, but it's not automated, and it's much more difficult.
So in
One of
essence,
my clients ran a trademark search. It only cost $150.
oh, I see. Okay.
I would
So-
recommend the trademark search on everything you want to trademark later, because if you use a word or a phrase or an image that someone else has already used, you're precluded from using it.
Okay. So there is, so the recommendation is to go to a source that can get this information for you, but not necessarily, it's not in the public domain. Is that correct, Ed?
Right.
Okay.
And SCORE mentors have access to the law firms that do this kind of work in Lehigh Valley. There's
Excellent.
3 of them.
We have, let's go down to some of the questions in the chat. Susan Murray asks, what about ideas that include specific software? How do you patent that?
Software is a copyright. You have to copyright software.
So, all right. So you can copyright the software, and that's your protection.
Right. It's treated as any other document.
We have another one from Brandon Kelly. Brandon asks, does this offer protection for the product you create, including ones that are similar to another product?
If you get a non-disclosure agreement from everyone you disclose to, you can preclude other people from making that product. You have to defend your mark by writing a letter. They're called cease and desist. To anyone you are aware of is using your idea.
Okay. Kimberly Cramsey asks, she has a question. What if a patent has expired? Can the original inventor bring it back to life?
Yes, you can file to extend the patent, even if it's expired. But if someone else has started using the idea in the meantime, you may be precluded because it's in the public domain.
Okay. Raja from NCC asks, how do I determine whether I need a patent or not? Or, realizing that it is an expensive procedure or process in both in terms of time and money.
What I advise people to do is to compare the revenues they could expect from their idea to the $4,500 cost. And if the revenues exceed the cost, register. The reason for my presentation is that some people don't have $4,500 when they first get the idea. So non-disclosure agreements are essential.
Okay. Stacy asks, what types of things would you recommend small businesses should trademark? Or what can I protect under intellectual property?
Anything you want to prevent other people from using. It's usually a name or a slogan or an image, like a logo. If it's a common word and you don't care, or you don't think you can stop everyone who would use it, then you don't need to file.
Okay. Let's see if there's any others related to patents and IP. I think you may have mentioned it earlier, Ed, but what if I told somebody about my innovation? Is it too late to protect?
Without a non-disclosure agreement?
Yes.
It's
Maybe
too
I
late.
exchanged the idea over a glass of beer, and now my innovation is out there. How is it too late?
Yep.
So
You have to get a non-disclosure agreement in advance.
in advance of disclosing your information.
Right.
Okay. Yeah, that's something to be aware of as business owners and developers of new ideas and services. Can you, Ed, just walk us through simple procedures for getting a trademark? What are the first couple of steps people should take?
Put a superscript TM after the first time you use the word or the image or the logo or the slogan. For the first time in each document, and that includes websites, you don't have to put TM every time, just the first time that it appears. Most people put it on a letterhead that they use to send emails and hard mail. Then they're covered. After that, you have to go and file for registration and get one of the 2,100 lawyers to do it.
Okay. Let's see what else is in our chat box here. What is the cost of creating a NDA, non-disclosure agreement, and are there free resources out there that one can take a look at?
Yes, you notice on the slide, I put the word free, and it is free. You can get it from SCORE. You can get it on the web, on the internet. It doesn't cost anything.
Is getting an NDA painful process, Ed? I mean,
Yeah, in fact, yesterday someone hired me to write 100 of them a year, and I agree. He expects them to take about 25 minutes each.
because
I've
as
written 800 of them, and it didn't take even 10% of my time.
yeah. Um, as a small business owner, perhaps many of us kind of put the such documents or in the back of our minds, more interested in getting the product or the service out there, and so it's you would be well advised, everyone who is thinking of starting a business, that if there is any intellectual property to protect, even if you have, if you're not totally convinced, it's worth the effort to at least be aware of what you might be able to get as protection.
Curious,
Of course, I would say get yourself a SCORE mentor and a free NDA in the bargain.
Yeah, that's inexpensive, but the actual process of, you know, when you meet someone or when you're talking a business situation and you whip out your NDA, I think all the flags go up, and people might be hesitant to. So that's another challenge that you, as a small business owner, have to overcome.
Yeah.
Can I ask
A week ago, a new company asked me to review all their contracts and tell them whether they work. But before they would send me one page, they asked me to sign an NDA.
Yeah.
Of covering everything they're going to tell me, orally, in writing, email, letters, everything. Of course, I was willing to do it because lawyers are bound by the same duties anyway. You can tell a lawyer without an NDA because a condition of his law license is that he keeps everything he hears from you confidential.
Right. It's attorney-client privilege, I guess.
Right. It's part of the code of ethics, and you lose your livelihood if you blabber out.
That's good to know. Jeff French has a question. He's in the audio-visual field. I am working on names for technical products and finding it difficult to come up with names that are not already in use. Can I add alphanumeric characters or change the spelling for a name in use to overcome this difficulty?
Well, the legal test is, would an ordinary consumer with no knowledge be confused by your mark because it's too similar to some other mark? If you're using your mark in a business that's totally different than the person who already has the mark or a similar mark, you're probably safe, because a consumer looking for your product or service wouldn't be confused. But if we had a customer who made ice cream, someone who used a similar mark to make soft drinks, sent her a cease and desist letter. That's a gray area. I mean, they're both foods for human consumption. So it could argue that a consumer of ice cream would be confused by a mark on soft drinks. But it's not exactly the same industry. So that's a gray area. It's a real problem. Those are probably the most troublesome ones because everybody can develop a different attitude, different point of view on whether there's confusion.
Jeff, you can unmute and ask a follow-up question if you like.
Yeah, thank you. Appreciate that clarification. I'm finding the audio-visual field and related industries, use the same naming characters and that sort of thing. So, it just adds to that gray area that you're referring to. It's difficult to find something that sounds technical and not encroach on one of the other industries or names that are in use.
Well, look at it from the point of view of a customer, and then that's the way the courts look at it. Does a customer who doesn't know anything need a technical term? Maybe you could make up something that's a little more in the mainstream.
Yeah, that's good advice. Thank you. I appreciate that.
Ed, enlighten us on this aspect. Does one need permission to use a picture or an image or a part of a song or a music video to promote their product or service?
Well, this is very interesting. I worked for a company once who wanted to circulate information that they received from a third party that said all rights reserved, the name and the year. So the copyright was preserved. We found that a case where a brokerage house did this, and they were fined $30,000 for every copy they sent out. It amounted to $1 billion. So we got very, very frightened because we had been using websites that had copyrighted or trademarked material on the website without paying anything, without even notifying anyone. We hired an expert who told us, thank goodness, that if there is a way to download material from a website, then they have granted you a free license. Under the law, there's no liability for downloading something that you're able to download.
And then you are free to share it on your own platform?
Yes, then you can transmit it to third parties. But what the brokerage house in St. Louis was doing was taking a written, hard copy they received in the mail and distributing it to dozens of other people. Don't do that. Congress changed the law a few years before that to state that you can recover, the owner of the copyright or trademark can recover its actual losses or a minimum of $30,000 for each sharing. And so they don't have to prove damages. They can come after you for $30,000 for every person you shared it with. But if you find something that allows you to download from the internet, then you've been granted a free license. and the right to pass it on to anyone you want, as many people as you want.
Even if the internet image or picture includes the TM sign or copyright or all rights reserved, etc. Even if it says that it is considered a free download. Am I right?
Right. Well, you're right. What they have is a preserved piece of intellectual property, but they've granted you a license to use it.
Okay.
You can't just steal it, but you can download it because you're a licensed.
And that
user.
works both ways, I guess, for somebody who's posted and someone who's trying to download as well.
Right. If you have a patent or trademark or copyright and you allow somebody to download it, you just granted them, you haven't lost the intellectual property right, but you've licensed that person, anyone who does that, to use it without paying you. So be careful if you don't want anyone to have that, don't allow it to be downloaded.
Okay, that's good to know. A follow-up question in the same general area is if somebody would assist me to build the product or the product idea, do they have rights to the creation of the idea and any future sales, etc.?
This is the golden rule. He who pays for the work owns the intellectual property that results, no matter who did the work. He who has the gold rules. So if you're working for someone, employee or contractor or in any capacity, and you invent something, it belongs to the person who paid you, not you. This is commonly confused. But if you just think about the golden rule, follow the money, and that's who owns it.
As a follow-up to that, Ed, can one get a patent if employed by a company? I think you just answered that, but what if the person developed this product or idea on their own time, on weekends and evenings, not related to what the company is doing?
Then the golden rule doesn't apply if there's no money changes hands.
Okay.
It belongs to the creator, and unless he's paid by someone else to create it.
Okay.
So can I have a follow-up question on that, Girish?
Yeah, sure. I think we'd like to open it up now to the general audience. Unmute and ask your questions. Raja, please go ahead.
So Ed, I got a question for you, right? So we have got a couple of students that are working on their own idea. They necessarily don't have any kind of an IP filed yet or a patent filed yet. And I think one of the things that they're trying to understand is that, whether the idea that they are pursuing has value or not. But they are in the process of, producing prototypes and working with, folks that are assisting them. So what you're saying is that for any materials or anything that goes into that prototype, if the students purchases that, then technically the student owns the idea, correct?
Right, under the golden rule. Mm-hmm.
Yeah, and so in that case, so it is very important for them to keep track of their receipts and anything else that goes towards developing their prototype.
Anything they disclose must be preceded by an NDA to preserve their right to register.
Yeah.
There's also a time clock running from the first disclosure, even with an NDA. A clock starts running, and you must file to register at least a preliminary patent. I believe it's within 1 year of the first.
That is the provisional patent, correct?
Well, that's the first step, yeah. But I urge people to check, because that changes, to check with a patent lawyer. They changed the law about 15 years ago. They changed patent law from the person who first had the idea to the person who filed first. You probably remember the old story of Alexander Graham Bell and Elijah Gray. They both invented the telephone.
Yeah. There
was a long 20-year court fight over who thought it up first. Nowadays, that wouldn't happen because Congress changed the law and said, whoever filed first wins, no matter who thought it up first. So don't wait forever. Somebody else files ahead of you. Even the Johnny-come-lately, they win. It's a paper rush. You know, it's like deeds in the states where the person who files a deed first owns the land, even if he didn't pay anything. It's called RACE, R-A-C-E. So don't wait forever to file to register, because the NDA doesn't protect you from people who file ahead of you. Do you see what I mean? It protects you from losing it to just anyone in the world, but it doesn't protect you. The NDA doesn't protect you from people who file to register your idea before you do. Plus, there's a statutory deadline. You can't wait. You can't wait forever. Does that help?
Yep. Thank you.
Anyone else wants to ask a question? Stacy.
Hi, Ed. I wanted to ask you about this download thing because I've never heard this. So you have all of these artists and photographers and musicians and creative types on the internet sharing this is how they're selling and getting people interested in their works. So they're sharing their works, and a lot of times they're sharing them on social media or sharing, like on Pinterest or Facebook. But it's very easy to download from those sites. If you post an image on Facebook, anyone can right-click it and download it. So if you're an artist or a photographer or anything, and you post an image of your creative works, even if you have it marked all rights reserved, anyone, like if you post it on social media, now anyone can use it for free. Am I understanding that right? That's crazy.
If you you still own the intellectual property. You've just licensed the person to whom you enable to download. You can't collect money from them, but you can prevent them from using your work. You just can't make them pay a license fee.
So how would you prevent them to, like, if you share it on social media because you're looking to, attract people so that they know that you're out there, then how do you keep them from, is that a policing thing? Like you need to make sure they're not downloading it and using it?
Well, if you have TM, you can prevent them from using it to make money and compete with you, but you can't prevent them from possessing it if you've put it on a medium that allows them to download.
So like if they wanted to download it and use it in advertising for something else, or use it in a company used it as an image in their blog post, like you can't prevent them from doing that if you put it out there.
Well, you can prevent them from making money.
Okay.
You can collect any money they make. The test, the formula is you can collect any profits they made or any profits you lost, whichever's larger. So one of my first lawsuits was about that. It was a heat treating company wanted to recover from their employee going into business against them. And they did recover. But the irony was the jury found that neither one of them made any profits off it. So the inventor won, but got no money. But he couldn't prove that either he or the thief ever made any profit off the idea. So I would advise people who are aware that their idea can be downloaded, take some steps to avoid that.
Can I talk
Get it?
to that point? Just I'm in the creative field. I'm an architect, and there's all kinds of issues related to copyright law and our intellectual property and all those kinds of things. I know quite a few photographers also put watermarks on their photographs so people don't, because it is very easy to right click on anything on the internet and take it. So a lot of the photographers that understand this process will watermark any photos that they are putting online just so that they know whose property it is and things like that. It comes down to like very careful contract writing as well, and making sure that your documents have copyrights on them, releases on them, or that the way that the contract is written gives owners the right to use your work in a certain way. Like we give a license to have copies of the drawings for permitting and things like that, but they can't just copy it and send it out to every contractor that they know. There are very important pieces of the law that are related to different types of creative work. So it's just important to understand the law and work with an attorney that understands your intellectual property laws associated with what you do as a professional. So it's a little different for, I think, a lot of different types of careers. Like what we're creating as drawings and designs. It's not an actual building or a product. So it's kind of interesting how the law relates to those kinds of things. So it's just, you have to be careful how you advise people when it comes to certain types of creative work. Is just all I would add.
Thank you.
I couldn't have said it better myself.
Ed, as a follow-up to that, many small business owners, and I'm talking about in particular those who are either starting out, have been in business for a number of years or a few years. We often hear the lament, I don't have the resources to sue someone who is infringing. So why bother in patenting or trademarking my product?